The case of Conagra Inc. and McCain Foods Australia Pty Ltd is an appeal from a single judge of the Federal Court to the full Federal Court. Presiding justices were Their Honours Lockhart, Gamow and French. This is a very important case that considered in detail the tort of passing off, specifically whether it is necessary that a plaintiff carry on business in Australia to maintain an action for passing off. The second major point of law considered by Their Honours was the significance of fraudulent intention on the part of the defendant in a passing off action. The plaintiff, Conagra, was an American company in the frozen foods business that had a significant share of the frozen dinners market in America and sold its products internationally. Conagra did not sell any of its products in Australia or have any business dealings in Australia, but was seriously considering entering the Australian market. Conagra's frozen dinners were marketed under the brand name Healthy Choice. McCain Foods, a company based in Australia but a wholly owned subsidiary of a Canadian company, commanded a large portion of the frozen dinners market in Australia. Before Conagra attempted to enter the Australian market, McCain trademarked the phrase Healthy Choice in Australia and began using the brand name to sell frozen dinners using a very similar get-up to Conagra's Healthy Choice. Justice Lockhart provided the leading judgment and discussed in depth the tort of passing off. The fundamental principle of this tort is that no one may pass off their goods as goods of another. This principle is expressed by the following elements. Firstly, that the plaintiff must establish that a reputation exists in relation to their goods or services, whereby potential purchasers associate a product or service's branding or get-up with those sold by the plaintiff, due to their distinctive nature. Secondly, there must be a misrepresentation by the defendant to the public, whether intentional or not, leading or likely to lead the public to believe that the goods or services offered by the defendant are the goods or services of the plaintiff. And thirdly, this must cause or be likely to cause damage to the plaintiff's reputation. Conagra argued and presented evidence trying to show that a significant proportion of the Australian population was aware of their products and therefore a reputation in relation to their products existed in Australia. The trial judge found this not to be the case, and Their Honours unanimously agreed. In relation to this conclusion, however, Their Honours discussed at length the question of whether Conagra need to be actually conducting business in Australia in order to establish that goodwill towards their products exists in Australia. Old English cases such as the Crazy Horse case found that it was necessary for business to be carried on in the jurisdiction that a plaintiff was arguing reputation exists. As Their Honours plotted the progression of the common law in Australia and other common law jurisdictions, it is evident that the position has changed as a reaction to increases in international trade and information sharing. The more prevalent view is now that it is not necessary to carry on business within the territory to establish as a question of fact whether reputation or goodwill exists towards the product or service in question, such that consumers and potential consumers are likely to be deceived and the plaintiff's reputation damaged. Their Honours unanimously agreed with this view, the first Australian appeals court to do so, but found that Conagra had not demonstrated such a reputation in relation to their product in Australia. The second major question of law considered in this case was whether fraud is a relevant consideration in an action for passing off. Their Honours agreed with the trial judge that the defendant likely acted fraudulently in designing the get-up of their products so similarly to Conagra's product. However, this finding is not enough to overcome the fact that Conagra could not establish that their product had a reputation in Australia. The unanimous decision was for the appeal to be dismissed and for the cross-appeal in relation to the trial judge's finding of fraud also to be dismissed. This is an important IP law case as it updates the common law position on misleading conduct and the passing off action in Australia to reflect modern commercial realities.